We're going to get started with our program today, how employers can prepare for immigration audits and visits. And we're going to start with our presenters, and let me introduce them. I'm Carrie Hoffman. I'm a partner in the Dallas office. Pamela Johnston, who's a partner in our Los Angeles office. Mark Newberger, who is of counsel in our Miami office, and Anita Sorensen, who is special counsel in our Madison office. And with that, I'm going to turn the microphone over to Anita.
Thank you, Carrie, and thank you everyone for joining us today. We're going to cover a few different topics related to the hot topic of immigration enforcement. We'll first start with the overall landscape. We're going to talk about various things that we see coming. We're going to talk about some employment-related considerations and considerations specific to healthcare facilities. So turning to the current landscape and how things are going with immigration enforcement, we know that there was very light enforcement during the prior 4 years, and immigration became a very big issue in the recent election. And the new president vowed to return to enforcing traditional immigration laws and do so vigorously. And indeed, he has started out that way. On the just within hours after the inauguration, he issued a number of executive orders, including the lead one on immigration, protecting the American people against invasion. He instructed the agencies within the executive branch to do full enforcement of the immigration laws and use all lawful means to do so. From that point, the agencies have been trying to implement the president's executive order, and we've seen a shift of investigative and prosecutorial resources. So Liz, if you can go to the next slide. Thank you. The main agencies that focus on immigration enforcement are the Department of Homeland Security, the Department of State, and the Department of Justice. The Department of Labor comes in with employment-based issues with immigration. So we've seen all of these agencies ramp up their efforts on immigration enforcement. Certainly the Department of Homeland Security has been the most public. We've seen the focus on removal operations, particularly people that have criminal backgrounds. Border security is up. There's been a 97% drop in encounters at the border, and there's been expedited removal of people who have entered unlawfully within the last 2 years. That's a very powerful tool that many administrations have used. The last administration did not use it, but it does allow the executive branch to remove people more rapidly from the United States when they're not lawfully present. We will expect to see continuing focus on removing particularly people with criminal backgrounds expeditiously and border enforcement, but we also expect the government to move towards civil enforcement of and employment-based enforcement in the immigration area. So one of the ways that we think that will ramp up is through much higher I-9 inspections. As we look back, we know that Mr. Homan, Tom Homan, is the border czar, and he was the acting ICE director in the first Trump administration. He vowed to increase I-9 inspections about 25%, and he made it to 21% and would have made the 25%, except we ran into the pandemic and then I-9 inspections stopped. So we expect the government to use this very powerful tool of I-9 inspections very soon. Probably over the summer to the fall time, we'll see those ramp up. There also may be more E-Verify audits. Now, the government the current government favors E-Verify participation. So they want that also to be a carrot. So there'll be a little bit lighter touch on that, a friendlier touch than there will be with I-9 inspections. That won't be a friendly touch. There'll be aggressive enforcement on that, we anticipate. Now, the Department of Justice, and you'll hear more about that later in our presentation, but they have also ramped up aggressively enforcing the immigration laws and pursuing criminal charges for immigration-related violations when supported by the evidence. So that would be more of the first choice to go to that when possible. They also have been pursuing jurisdictions that they believe characterize as uncooperative. Those jurisdictions are usually called also sanctuary jurisdictions, where they don't participate in cooperating or assisting the federal government with immigration enforcement. As part of the push we believe will happen more in the summer and the fall time after the current push on the criminal removals takes place, we believe that there will be more site visits to employers that have commenced immigration cases. Some of you are familiar with the H-1B and L-1 religious worker R-1 cases, where there has been a fraud detection and national security officer visiting, or a Department of Labor officer. Those will start happening again. There was very little of that during the last 4 years. Some started in December, and we expect that to keep ramping up. And overall, there's going to be more scrutiny on immigration cases that go forward. So for employers, when you're reviewing and signing under penalty of perjury, it's very important that you take a good look at what you're signing, make sure that you believe it's all correct, and that you would be able to respond to questions if an officer stopped by and start asking those. So we can go to the next slide again. One of the additional moves that the administration made was to change how it would administer what's called in the enforcement policy in protected or sensitive locations. Most of the administrations dating back to the Clinton administration had a policy that required special care to do any type of immigration enforcement in a protected area. Those protected areas were traditionally medical facilities, schools, and churches, places of worship. The Biden administration added several more: social service centers, daycare, homeless shelters, and others. The Biden administration also moved the approval requirement to headquarters, that you couldn't do enforcement in those types of areas unless you had Department of Homeland Security headquarters signing off in Washington, D.C. And unless there was like exigent circumstances, if the officer was chasing somebody, or there was national security or other types of public safety types of things. So that was a very narrow use of enforcement in these areas, much more narrow than any other administration. The new administration changed that policy, rescinded the prior memo on what had happened over the last 4 years. And Liz, we can go to the next slide. And has implemented, and that caused a lot of concern when that policy was rescinded, because folks didn't know, what does that mean? Is there going to be regular enforcement in these protected areas? That turns out not to be the case. The new administration issued a policy where they are focusing on what they call common sense and good judgment by the officers. The main change was that they moved the approval from Washington, D.C. to the local and regional offices. So the immigration official, the government official that is in charge of various enforcement initiatives, will be making the decision on whether to enforce at a protected area. So we, again, don't think, as this policy plays out, we haven't seen any significant enforcement activities in sensitive places, and we think that that's going to still be used very sparingly. It's just that they're not going to have to ask headquarters in Washington, D.C. It's going to be the local, top level officials at the local or regional offices making that decision. So Liz, we can move to the next slide. So how is the new administration going to be able to do this widespread, vigorous enforcement as they have forecasted? particularly when there's been an unprecedented number of entries through irregular means outside of the traditional immigration framework. And the way the administration has done that is they're basically all hands on deck with the entire federal government. Many federal agencies that have traditionally not been involved in immigration enforcement or only on the periphery are now making it a main focus. We have the primary enforcement divisions of the Department of Homeland Security, which we know are Immigration and Customs Enforcement, and its specialized unit within Immigration and Customs Enforcement. And many of you have heard the acronym ICE. And that is this main initiative to do law enforcement in the immigration area. The specialized unit that does, you'll see them in the I-9 inspections and criminal investigations, Homeland Security investigations, national security, those kinds of things. Customs and Border Protection are the officers that we see at the airport and the land borders, and they have traditionally been the focus, but they're getting a lot of support now from other federal agencies, the Federal Bureau of Investigation, the Department of State's Diplomatic Security. Those folks usually focus on visa fraud, but they're expanding and basically helping ICE quite a bit, and then other federal agencies. So we're really ramping up the amount of force that's coming to vigorously enforce our immigration laws. Liz, we can move to the next slides.
Anita, we're having a problem. Some people are not muting their mics, and there's a lot of feedback. So everybody who's other than Anita, please mute your mics.
Thank you, Mark. Yes, if you could mute your mics, that would be helpful, so all of our listeners can hear as best as possible. Thank you very much. So now we're going to turn to how do we deal with law enforcement making site visits to our facilities. So Liz, we can move to the next slide. Thank you. So we know that with this vigorous enforcement that right now is focused primarily on criminal removals, people that have final orders of removal, and folks that came in the last 2 years. But we also know that the government is going to turn to look at our employers and our other facilities. So how do we deal with those visits? It's helpful to think of Immigration and Customs Enforcement, even though, you know, that sounds fairly intimidating, that they're police officers, but they're specialized law enforcement. And when we think about employers that have dealt with OSHA, the Occupational Safety and Health Enforcement officials, those are also specialized in enforcement agents. So we'll just think of ICE is coming and their specialized law enforcement, and how do we deal with law enforcement when it comes to our facility? Many of you might have policies, and it's a good time to review your policies. If you don't have policies, it's a good time to outline, okay, this is what we're going to do when ICE comes to visit, or someone that's helping ICE. Could be the FBI and the other agencies we talked about. It's important to train employees so they know how to react when ICE or the federal government shows up. And while we don't want the receptionist, or maybe the security guard handling these issues, we want them to know what to do when ICE comes. And that's why we need some point people. It's good to have two in case someone's not available, but liaisons who will be trained and be able to implement the response that's appropriate that your organization wants to take in dealing with law enforcement. So we want the frontline people who ICE might meet in coming into the facility know to go to your liaison, your point people. And with that, I'm going to turn it over to my colleague Pam, who will help us understand what we should do from there and how we further can prepare for a visit from law enforcement. Pam?
Thanks, Anita. So Pam Johnston, I'm a defense lawyer and help companies and individuals in connection with government issues, basically. Usually DOJ's on the other side. We can go to the next slide, please. Okay, so we're going to talk about search warrants and arrest warrants, something that some of you may know a lot about and others may happily have never seen. Warrants, when you think about warrants and what the authorities are allowed to do when they come to your place of work, they're allowed to go anywhere the public can go. So you may want to think ahead about what do you want to be public. If you're a public agency, say a public hospital or a school or something, you may have state law limitations on what can be considered public versus private. If you're a private organization, it's a little bit easier. And you can, most of the time you can set your boundaries where you want them to be. So if there are places where you want your, say it's a patient in a medical center or a client in a public space, just think about it ahead of time so that you're not having to make the rules up as you go. And if you want something to be public, that's where the agents can go without any permission, like anybody. If you want it to be private, you want to make sure you label it and you have some kind of barrier or something on the floor or something that indicates that's not an open area that the public can wander into. We encourage you to think about these things ahead of time as opposed to trying to do it on the fly. And again, if you are a public agency, you probably have to consult both local ordinances and state laws about what has to be public. You're going to have some limitations. Next. All right, this is very basic. If an ICE officer is coming and wants to arrest somebody on your premises, if that ICE officer, if she has a warrant, has to look at the warrant. Next, please. There are lots of different kinds of warrants, and you, as an employer, can consent. You don't have to insist on a warrant. Whether the person has to go with the officer is a different matter, but for purposes of controlling your facility, you can consent or you can choose not to consent. Something that we'll go through here is that not all arrest warrants allow someone to come into your private space to arrest somebody. It's if you don't do this all the time, this is not common sense. So that's why we're going to cover it. Next, please. All right. There are certain kind of warrants that are signed by a judge. In the federal system, the judge is signed as a magistrate judge, but it's still a federal judge. In the state system, it's typically a state judge assigned a duty. And for these federal kind of immigration offenses, if it's a judicial warrant, 9 out of 10 times, it's going to be signed by a magistrate judge. It's going to be a federal warrant, not a state warrant. We look to see if it's got a court's name at the top. You look to see if it's actually signed by a judicial officer. And you're looking to see what is the authority that's been granted by the warrant. Next, please. All right, so here's a sample of a search warrant. What does a search warrant do? It allows the person or persons identified in the search warrant to go to a particular location within a limited time frame and search for whatever's listed. Often that's financial records or that kind of thing, but when we're talking about immigration, if it's a standard search warrant looking for illegal immigrants inside a business, for example, then they can actually enter the business and search for the persons listed. So you can use a search warrant to go inside a business to look for persons, not just documents and records. The thing that if you don't do this all the time that you won't know is that an arrest warrant does not give an officer the authority to enter a private space. That requires a search warrant. Some of the ICE agents won't know that either because they won't have come across it. It's why they're going to try to do arrests in parking lots, in public spaces, at a jail, things like that. Next. Okay, what's an arrest warrant? What it sounds like. But again, it doesn't give authority to enter a private space to search around and look for somebody. It does give permission for the officer to take someone into custody. And if you haven't had somebody go through the immigration system before, we have a parallel jail system for people who are detained on immigration arrests, and they go into an INS holding facility. Next. All right, the administrative warrants you're going to see are a little more common. So these are the typical things the ICE agents will use to take someone into custody. This is not issued by a judge. It is issued by somebody authorized to issue it, and it's from the immigration agency itself. It's from ICE. So it's not a search warrant. It is an arrest warrant. And if it's signed, then you need to let the person take the person into custody, again, assuming it's in a public space of some form. Next. All right, this is a very typical warrant that you will see in any case where someone has been removed or deported. By the way, and as Anita knows, she's our immigration expert on this call. Removal and deportation, it's the same thing, different statutes at different times called them different things. But they're equivalent, for our purposes, they're equivalent terms. It means that someone can be removed from the United States, and this is the piece of paper that gives the agent the authority to take the person into custody and then remove them from the United States. Again, same rules. Because it's an arrest warrant, it's a type of arrest warrant, it cannot be used to enter a private space to get to somebody who is, say, working in the back. If you have employees that are in a private part of the business, this cannot be used to go get them out of the back. Next. All right, I'm touching on this because this is a rarely used warrant that we haven't seen, I don't think, in 20 years. But there was some mention at the beginning of when all these things were being announced in January and February that we could see these again. What a Blackie's warrant is a civil search warrant to be able to enter a premises to search for persons who are illegally in this country. So it typically is issued by a federal magistrate judge. It says Blackie's on top of it, and it allows them to go in to look for the people inside. It's been a very disfavored warrant for at least 10 years, but we might see the return of a Blackie's warrant. It's called that because of a case out of DC. When I was a prosecutor, I used to approve these, sign them, send them to the judge, and have agents go and investigate inside a business to look for persons who were illegal in order to prosecute the company for having undocumented aliens being employed by the business. Next, please. All right, triage. This is not me. This is Mark. So please meet Mark Newberger from our Miami office, who's going to talk about this next topic.
Thank you, Pam. So I'd now like to focus on you all as employers and what you can do to prepare for and be ready for what is, greatly unexpected. And that would be number one, if you get any advance notice of any type of law enforcement action, audit, or the fact that people may be coming to visit, do what you can to buy a reasonable amount of time and get a copy of the warrant so you can make an assessment of what you're going to do. That will also give you appropriate time to check with your legal counsel or a point person. These are things you should be having internal discussions about now. What would we do? How would we respond? Who's going to be responsible? Create a response team, if you will, to triage these things and take specific responsibilities. Reviewing the warrant to determine what the company's organization's obligations are and how to interact with law enforcement. One of the things you're going to hear me talk about today is what you don't want to do is be accused of inhibiting law enforcement or obstructing justice, because that will get you arrested and criminally prosecuted. And it would be fair to speculate that the government's looking for those kind of cases to make an example. So start planning now, create a response team, and be consulting with your attorneys. Next slide. So what are the employment considerations? Next slide, please. So this is one of the few areas of employment law where if you mess up, you could go to jail. These are criminal acts that could arise in the context of an employer-employee relationship. And they include a pattern or practice of hiring undocumented workers. 8 U.S.C. is the federal criminal code, and that's a misdemeanor. Harboring or shielding undocumented workers from detection. Making false statements on a federal matter or false attestation on a Form I-9. That's perjury and visa fraud. Knowingly hiring 10 or more unauthorized workers in a 12-month period is a specific criminal statute, recognizing that maybe you could make a mistake once or twice, but if you hit the magic number 10, that's a pattern in practice. Encouraging or inducing undocumented workers to remain employed in violation of the law. And we're going to talk about this. This is going to be critically important to all employers out there today and then in the days to come, as people with valid immigration status and valid work authorization have those statuses revoked by the government, no longer making them employable. And then forced labor and benefiting from forced labor. Some of the classic examples of what this is where you seize people's papers and you basically imprison them and force them to work in illegal in an illegal and inappropriate manner. Next slide, please. So what are we seeing? Well, one, we're seeing increased Department of Homeland Security enforcement strategy in conducting I-9 audits and imposing files. Something very important to remember about I-9 compliance, and that is, even if you have an improperly completed I-9 on someone who's totally valid work authorized, Mark Newberger, born in Brooklyn, New York, no doubt about his immigration status, but the I-9 is improperly completed, that can subject an employer to fines, and the fines escalate. There's a specific range of fines for each improperly completed I-9 form. Getting involved in a joint employment or temporary agency relationship where it's not clear who the employer is, and holding all parties responsible. One of the biggest immigration enforcement actions ever was against a large national retail department store chain over the maintenance workers who were all contracted out by a maintenance company. And the department store, even though they were not the actual direct employer, was held responsible because they knew or should have known of the illegal conduct of the contractor in employing unauthorized workers. And again, this is something that has both civil and criminal penalties. We also are seeing combined task force of multi-law enforcement agencies. These are the federal ones, but we're also seeing the combination of state and local law enforcement working in conjunction with the federals. And that's being required in my home state of Florida, where I'm coming to you from. Our governor has taken all kinds of specific actions to ensure that local law enforcement is cooperating with federal law enforcement on immigration enforcement matters. Next slide, please. So what is required for I-9 compliance? Well, number one, all new hires at all employers must properly complete in a timely fashion the I-9 form. That includes the employee filling out the first part, presenting the appropriate documents, one from column A or one from column A, B, and C. The employer looking and reviewing that to confirm the identity and the employment eligibility, and that they have a good faith belief on this person is who they say they are and they're eligible to work in the United States. And then if you're required, and many states and federal government contractors, for example, are required to run E-Verify, that involves taking the I-9 form and running it through a computer system to get the federal government to confirm the employability status of the individual. As I know, 23 states now have laws which require some or all employers to use E-Verify. Federal government contractors are required to do it, and you have to maintain the records. At the same time, these laws, the Immigration Reform and Control Act, which created the whole I-9 process, has a non-discrimination provision that says you can't discriminate on the basis of national origin, citizenship, or immigration status of people who have lawful status to work. And you can't require more than what's the minimum required by law. You can't over-document or force certain people to have different kinds of documentation. One of the greatest things the government ever did was create an employer handbook for I-9s. It's a great document. It's in plain English. It's on the web, and it shows you samples of the types of documentation that are appropriate. Next slide. What is a good faith belief of work authorization? Actual constructive knowledge that the person's unauthorized may be found by improper or missing I-9s, expired temporary worker authorization. Some of these are common clerical errors that can be made by people who are well-intentioned. Attention to detail on the I-9 is critically important. One of the things I do as an employment lawyer here at Foley and Lardner is get to work on buy-sell transactions for companies. The companies that are buying other companies or investing in other companies increasingly want to make sure that the company they're buying or investing in is in compliance with I-9. So I regularly audit I-9s in these buy-sell transactions. And I can tell you the rate of errors that I see at many companies, 50, 60, 70%, most of which are clerical errors due to inattention to detail or not taking the time to properly learn how to fill out an I-9. You know, the other one is well-intentioned employers who the employee, for whatever reason, loses status or comes to you and says, Mark, I'm sorry, but, you know, I duped you when I got hired 3 years ago. I'm really undocumented. Please be a good guy. You see, I've been a good worker. And for a charitable reason, the employer decides they're going to keep this person employed. That's a crime, okay? And that's a problem. And you can be sure that the current administration is looking for opportunities to enforce against that. So well-intentioned but inappropriate or illegal conduct is not going to save you. Using contractors or staffing agencies to avoid I-9 requirements. I gave you an example of the large national retail chain that contracted with a janitorial company who engaged in the violations, and then failure to respond to government notifications. Next slide. So what may happen? What we call knock and talk. They show up at your door and they ask you to voluntarily cooperate. You may get a notice of inspection on your I-9s in writing. You have 72 hours to produce all your I-9s when you get that. That's an incredibly short period of time. Or, as we've been talking, and you'll hear a little more, you get a workforce raid, literally where law enforcement circles the building and comes in and starts grabbing people. And with that, I'm going to turn it back over to Anita.
Thank you, Mark. Okay, we're going to talk a little bit about the I-9 inspections, and this will be an overview. This is a very dense topic, so there's lots of nuances. We're going to give an overview today, and we'll be looking for more discussion on I-9 inspections as we go forward. As we discuss, we expect this to be an area of intense focus by the government. So we talked about ICE, or Specialized Unit at HSI, Homeland Security Investigation, will initiate the I-9 inspection by serving a notice of inspection upon an employer. That is usually done either by certified mail, or if ICE wants to reduce the time and limit it as much as possible, they will come on site and serve it, the notice of instruction. That notice of instruction will say you can waive the 3 business day period you have to respond and produce your I-9s if you would like to. And that would always be a mistake. It's never a good idea. That is a very short period, as Mark mentioned. And one of the first things I do when I'm helping defend an employer and a notice of inspection is usually ask the officer, try to set up a good relationship, good rapport with that special agent that's on the case, and see if I can get a bit more time. That previously was more doable. Most officers would agree. During the first Trump administration, it was difficult to get extensions. They would really look at, well, why do you need the extension? Consider the size of the employer and how many I-9s you'd have to produce, whether there was a holiday period coming up, something. You have to have some good reason to, other than we're just not ready, some good reason to get that extension. But that extension is important, and the lawyer would try to get that for you as a first step. When ICE issues that notice of inspection, that will say the I-9s they want, and they'll ask for all current employees and usually a period of the terminated. They can go back through the entire retention period for I-9s, which we know is 1 year after the date of termination or 3 years after the date of hire, whichever is longer. Sometimes they only ask for a year of terminated, which is usually very helpful. So you want to look carefully with your counsel about what that notice of inspection says. How broad is it? Is it for all locations or just one location? And you want to try to limit it as much as possible. If you do have the benefit of it only being one location, then while you focus on that location, you'll also want to be preparing for the other locations in case ICE goes there shortly thereafter. ICE also, or HSI, its specialized unit, also asks for supporting documentation. They'll ask for the most recent quarterly payroll, a list of the active and terminated employees within whatever period they're requesting the I-9s for, and then business information. They ask for your business information about your structure and that kind of thing, your corporate structure. And then they ask for certain contracts. They want to know if you're a federal contractor. They also want to know what contracts you have with temporary staffing agencies. And they'll take a good look at those because sometimes they're really focusing on issues with the temporary agency and they're going through you to get there. Or they might, particularly if HSI is involved, they might have come to you through a criminal investigation where they're pursuing a document fraud ring and they trace the documents to your location and they're not quite sure whether the employer is a good player or a bad player. And during this I-9 inspection, you really want to set up a good relationship and rapport with the officer to show the officer that you're the good guy. And if there's a document fraud ring going on or whatever the problem is, you, employer, did not know, and you're as much as a victim as others. With the temporary staffing agency contracts, they'll really look at how are you using the temporary staffing? Are you using it periodically during peak loads during the year, seasonal highs in demand for your product in the business, or are you really using it as a year-round extra source of labor, and why is that? They will look at whether that's a business model, again, to try to avoid the employment verification laws. And you should also know that they really will look at if they start pressing on that temporary staffing agency and believe that you, employer, didn't know that the temporary staffing agency is running a model where they're relying on people that don't have work authorization and maybe doing so knowingly. They'll look at how you reacted to some of the questions and some of the information that ICE is asking about your relationship with the temporary agency. So be very alert to that. During the process, which usually goes on for an extended time, the notice of inspection process, ICE will issue various notices. They could issue something called a notice of suspect documents, where they think the person is unlawfully present and doesn't have work authorization. They might issue a notice of discrepancies, where the ICE suspects that the person isn't authorized, but they're not quite able to reconcile it. So they'll ask the employer to follow up and give various instructions. Those notices are very important because they give you a certain time period to respond. For example, a notice of suspect documents, they will instruct you to meet with the employee, try to see if there's any explanation, any other documents that could show the person was lawfully present and has work authorization. And if you're not able to resolve that at the end of the period, usually 10 business days, and you continue to employ that person, ICE will treat that, the government will treat that as a knowing violation, and you will be subject to additional fines beyond you made a mistake in the paperwork. If the I-9 completion, if that happened, you will also have the knowing violation, and if it happens a lot, you might have the pattern and practice violation and other issues there. So it's very important. If you need more time because you think that there's an able to resolve, you're able to resolve the issue and show ICE that really the person is authorized, then the attorney normally would need to go back to ICE and get an extension, because without an extension, that 10-day run and you continue to employ that person, you have a knowing violation. And as Pam will tell us, that's something that the U.S. attorney would be most interested in using that evidence for criminal prosecutions too. Then the other notice that we should talk about is that notice of technical or procedural failures. If ICE thinks, okay, this is an error that can be cured, they will give you an opportunity to cure that. And they usually will give you 10 business days. If you get that, it's very important that you make that correction, because otherwise, if they gave you an opportunity to correct and you did not correct, then it will turn into a substantive violation for which monetary fines and other types of penalties can be assessed. So that's very, very important to do. Sometimes it's a little confusing about what ICE wants you to do to cure. So then again, if that's an open issue, the attorney will go back to ICE and discuss what type of cure ICE is asking the employer to do. So we can go to the next slide. So one thing that interests all of us, all employers, is we want to know, how is an I-9 inspection triggered? And they can be random. We want to build that culture of compliance. The ICE director under President Obama, John Morton, often talked about the best way to build a culture of compliance is to have robust I-9 inspections where an employer is looking over their shoulders and doesn't know where that's going to come. And most administrations have used that. The last administration, which we discussed, didn't. And now we're going to see not only returning to I-9 inspections, but vigorously so. So that's why we want to pay attention here. So just think about, beyond the random, building the culture of compliance, there are employers that would be at higher risk and more targets, those in criminal infrastructure, critical infrastructure and national security, those who are involved with the electrical grid. We always hear issues about that, transportation, certain technology, anything that can affect the public in a very bad way. The government will want to make sure that those employers have a lawful workforce. Industries that sometimes struggle with maintaining a lawful workforce are also targets: hospitality, retail, temporary staffing services, food processing, related manufacturing, construction and agriculture. Larger operations, and you might think, well, why is that so? The larger operations is because when the government is trying to get employers to pay good attention to I-9 compliance, they're trying to make a splash and get everyone's attention so they can get that with going after larger operations. Now, usually to make that big splash, they would also want to target larger operations that they have some concerns about. So they'll be looking at, do we see some aberrations, some problems there? Other employers that are risk, ones that if you start getting government visits, including from various other agencies, I would be more on alert that something might be coming from in the immigration area. So an I-9 inspection may be coming. If you've had a prior history of violations, so you have received you've had an I-9 inspection, you received a warning, which is the lightest sanction that ICE could give, up to a round of fines, you want to be extra careful. And then if you are the current focus of a criminal investigation, we talked about how sometimes an I-9 inspection can be done because the government's really looking to get information, and they can get that sometimes from the I-9. So that's a harder one to tell. And sometimes, counsel will try to figure out from the special agent why the government is targeting your operation. That information is usually pretty closely held until you get further into the inspection. But it's good to know why the government came. And of course, the best reason is if it's random, you just had bad luck versus some of these other things that the government has a concern. Another reason, we talked about government visits and inquiries, if you've seen in news reports that ICE has been active with enforcement activity in your area with raids or other things, if they've been there, they've been visiting other employers, I would definitely be concerned that the I-9 inspection may be coming. So we can go to the next slide, Liz. So we talked about the possible result there, and that can be with penalties and other types of sanctions. The government updates the fine schedule annually, and they just updated some of the fines in January 2025. So just for not carefully completing the I-9 form, according to the rules, you can be fined for that, as my colleague Mark mentioned. And the current rate of fines is between $288 and $2,861. And you can think, oh, we'll be in the lower range. Well, not so fast. It depends on the number of violations and the size of the workforce and whether you had people unlawfully present, all those things, good faith, cooperation, your history of violations. ICE looks at all those things to decide where you are. You can be a small employer. I have one that I'm defending. It's been a long pending case where the employer is actually below 100, so it could be categorized as a small employer. But if it has a higher violation rate, you can see how that could be a high fine over 100,000. So you really need to focus on that I-9 compliance. It's really one of the most complicated one-page form for sections 1 and 2 that exists, and it should not be treated as a clerical or administrative issue to deal. Don't push it down. Make sure your people are well trained and know what to do. And then, of course, if we did a bad job or a sloppy job on the I-9s, and we have people that are not authorized to work, that knowledge can be imputed to the employer just because we were sloppy on the I-9. They'll think, well, you didn't even really try, so you probably knew. And that kind of imputing the knowledge that the person was unauthorized has been upheld. So you can see all the other fines that can be added, and it can be rather substantial fines. So now I'm going to turn it back to my colleague, Mark, who's going to talk about some of those.
Anita, before you do that, we do have a question in the chat. And the question is, would other prior violations be a tip-off for I-9s, meaning does a prior OSHA issue reveal that you would have a location staffed by at-risk workers? And Mark, you feel free to jump in on that one as well.
I'm sorry, I missed that.
I'm sorry, the question was, would an OSHA inspection, for example, be a tip-off to government agencies that you may have an I-9 problem?
So I can only talk about my past experience of 30 plus years. Despite, historically, agencies haven't talked to each other on these. I have had wage hour investigations where I believe there were immigration law violations, and I was waiting for the wage hour inspector to call the immigration people, and they never did. Historically, they haven't. We're in a new era. I think you'll see a lot more joint enforcement, and it's a possibility. But I can only tell you that historically, I haven't seen that.
I guess if I can also chime into that question, I think that I would say that OSHA, when I mentioned that you need to be thinking if you've had other visits from Department of Labor or OSHA, I don't think that, they usually, Department of Labor sometimes looks at the I-9s, OSHA usually doesn't, so they may not be knowing how your paperwork's enforced, but I do think that all the agencies are now talking to each other. There's even more discussion of the IRS sharing information with the Department of Homeland Security under certain circumstances. And that's, while they've always done so in criminal investigations, that's been talk of expanding that. So I do think there's going to be more discussions. And while I don't think OSHA would know whether you have good I-9s or bad I-9s, they would see your workplace, and I would be a little bit more alert on those issues with I-9s. And the best thing to do is just really focus on doing good I-9s, and then you'll be ready.
There's another good question in the chat, and I think it's for Pam.
Yes.
And that is, if, let's say, a federal agency shows up with a warrant and with them is a local law enforcement agency, do they have to admit the local law enforcement agency under the scope of the federal warrant?
A typical warrant, thanks, Mark. A typical warrant does not have the agency that's executing the warrant listed in the warrant. It's just addressed to an officer. And then it would be a question of, most likely, if there's a local person who's coming along, and it happens all the time, by the way, nothing to do with immigration, they just need to make sure they have all their P's and Q's of basically like a task force. So if they're serving on a task force, they typically have memorandums of cross designation, and they can go, and the locals can arrest on federal and the feds can arrest on local. It's not the kind of thing that I would fight with at the door, right? That's an issue for another day. If somebody was not properly involved in a search, you could try to, have the search suppressed. If they're at the door, I would let anybody who has a badge and a gun come in, basically, is the sort of rule of thumb. While we're on this issue of the knowing violation, so everything you just described there, these are all civil penalties. What's different is now there are criminal penalties on top of civil penalties. So this is just basic civil stuff that you could have to pay a bunch of money for. But, liberty starts to become an issue if you've got knowing violations, essentially. I wanted to ask, while we're on this little break, I wanted to ask Anita, I've heard that the ICE is going to be hiring vendors to do these audits for them, so they'll get a lot more audits done. What have you heard most recently about that?
Well, they already have a special unit outside of Washington called the Employment Compliance Center, ECC, where when they have larger raids, they have a team of auditors that they refer that to. The prior administration didn't use that center at all. It was pretty much dormant. I think that will be ramped up to help with inspections from large employers so they can handle those. I also believe that they will try to outsource with contract with some specialized vendors to expand. The whole thing the government's doing is expanding its reach so it can do as much coverage as they can. So I think first they're going to look at using that ECC unit, which was the specialized auditors. I have had during the prior the first Trump administration had an inspection where the special agent was in New York. The ECC was handling the preliminary review through those auditors because it was very, very large inspection, and the special agent couldn't do it alone. And as you know from your prior experience, the officers don't want to sit there going through all the I-9s. They want the auditor to do it, tell them the results, and then they're going to push the employer. I also wanted to say one other thing. When we talked about the notice of inspection and then ICE asking for additional documents, they usually issue an administrative subpoena for those additional documents. And as Pam explained to us earlier in the presentation, the employer can decide to comply with that or push the agency to go to court and enforce. And usually I pick my battles and I look at that subpoena and I try to see if we can comply with that. Oftentimes you can get extra time to comply because they don't want to have to spend the energy to have to go to court and enforce.
So,
you also need to.
and Anita, we're going to need to move along because we're running out of time.
Yeah, I'm sorry,
Okay.
everybody. I need to cut in here so I can read the CLE code for today. If you are applying for CLE credit, the CLE form is linked on your page. You can also use the button widget at the bottom. The CLE code for today is 57GJ7. The number 5, the number 7, G as in Google, J as in Julia, and then the number 7. One more time, that is 57GJ7. Thanks so much.
And then I think we have one more question in the chat I wanted to get, Pam. It was somebody who said they were previously not advised not to comply with administrative warrants. Is that improper advice?
Depends on how you like to live your life. Personally, I would never ignore a warrant. It's a bad idea. I think my guest, Leanne, feel free to call me offline if you want to talk about this, but in essence, what they're saying is the warrant isn't any good. That's not accurate. What it is that an administrative warrant is more limited than a judicial warrant. And so you have to abide by what's in front of you. And what we were talking about earlier, an administrative warrant does not give the officer the ability to go into the back of an organization in private space and arrest somebody. It does give the officer the authority to arrest somebody. I don't know if that answers the question, but I hope it does. Who would be liable for criminal penalties? Anyone who is in knowing violation. So as somebody who's to prosecute businesses for these crimes, I would target the business itself and senior executives, say in charge of HR, maybe in charge of a division that does all the hiring. And the one thing we haven't talked about yet is when you do put these cases together as a prosecutor, what you do is you don't rely on one set of documents. You have the agents go in once, take pictures, figure out everybody's there, get their real names, get their false names, whatever it is, get all the paperwork, and you send them back 30 days later. And if 10 of the workers are still there and they've got new names, but their pictures all match, that's a good case to prosecute because now you've got a knowing violation that they've invited back all these people who were not permitted to work there. So the first one is sort of the first bite. Maybe that goes civil, but if you come back a month later and half the employees are still there, then you got a good evidence of a knowing violation.
We have just a few more slides to get through. Some practical additional concerns for employers. If you've been following the news, people with lawful status have been having that status revoked. One of the areas it's been revoked is what's known as temporary protected status. Temporary protected status is an immigration category that allows people who came to the country undocumented. It allows them to remain in the United States because a determination was made by the Department of Homeland Security that it would be unsafe or hazardous to send them back to their home country. Until recently, there were 17 different countries that had granted temporary protective status to individuals. On February 1st, the Secretary of Homeland Security terminated one category of TPS designation for Venezuelans, approximately 350,000 people. On February 24th, she revoked all TPS status for Haitians and shortening the period so that the initial revocation period is August 3rd, 2025. That's approximately 500,000 people. And on March 25th, the Secretary of Homeland Security announced the termination of individuals from Cuba, Haiti, Nicaragua, and Venezuela who were given a special parole. This is different than TPS status, and that they would lose their benefits by April 24th. Here's the thing to know as an employer. If any of your employees are in these categories and they lose their status, they immediately lose work authorization, and you will be violating the law if you continue to employ them. Next slide. Now, all of these things are being challenged in the courts. As recent as 2 days ago, a federal court temporarily enjoined the termination of the TPS status for that certain category of Venezuelans. We're waiting to see what happens on the other legal actions. As of today, and I checked this morning, but who knows what happened in the last few hours. As of today, no additional injunctions have been granted. So if an injunction's been granted and the revocation is stopped by the courts, you can continue to employ those people, but understand that might change literally overnight. And so you have to be paying close attention as to what's happening to your workers. Failure to terminate, like I said, even with charitable intent, could subject the employer and individual managers to criminal penalties. And you can expect that there will be revocations of other TPS nations in the future. So, next slide. Just to summarize that point, what should you be doing? Auditing your I-9s to know who falls into these categories and very closely watch what happens. Pam?
Okay, go ahead.
Well, I think we're out of time.
I think we're out of time.
Yeah. So I think on behalf of everybody here, I want to thank you all for your participation. Thank you for asking questions. We appreciate it. And we will see you at our next webinar. Thank you very much.